Okay. Hello, everybody. Welcome to our very first webinar. We are the New Jersey Coalition for Learners, a nonprofit committed to advertising the education conversation through advocacy, resources, and support. Today marks the launch of a series of webinars created specifically to empower families as they navigate the special education system and related services. Tonight's webinar is being recorded. If you have any questions for our panelists, we ask that you type them in the comments. If your video is on, please turn it off. Please take a moment to like our Facebook page. We do post a lot of updates. Our next webinar will be posted on there. Also, you can join our private Facebook group for additional resources and supports. We will post both links in the chat, and they can also easily be found on our website. We're so glad to have you here, and we will start the process now.
Okay, so just real quick, welcome everyone. I'm going to read our disclaimer notice. This webinar is intended for informational purposes only and does not constitute professional, legal, or educational advice. The New Jersey Coalition for Learners provides opportunities for open discussion on various topics at no cost to families. All conversations, guidance, and information shared are meant to inform but should not be relied upon as a substitute for consulting with qualified professionals in legal or educational fields. Additionally, NJCFL does not endorse or promote the views, opinions, or expertise of any panelist or speaker. Panelists are invited to share their perspectives, and their participation does not imply agreement or alignment with NJCFL's mission or stance on any topics. So with that, we are very excited to welcome Lori Gaines, a special education attorney from the law firm Barger & Gaines. Lori brings years of experience in special education law and has helped countless families across New Jersey. So Lori, thank you so much for making the time to join us and providing this resource for families. I know you have a presentation to kick things off, so I just want to mention again that if anyone has questions along the way, please just put them in the chat and Lori will do her best to answer them as they come. So one last item, we can all learn more about Lori's work by visiting Barger & Gaines' website, which I will post in the chat now. And Lori, if you would please introduce yourself and kind of your background experience and take it away.
All right, thank you, Kai. Good evening, everybody. I'm excited to be here and to kick off these very important conversations that are going to be coming our way in the future about special education. By way of background, as Kai said, I am a special education attorney. I think I'm entering my 20th year. Hard to say that. But prior to being a special education attorney, I was a special education teacher. I have my bachelor's degree in special ed, and I have my master's degree in learning disabilities. And I taught for several years before switching over and heading to law school with the sole intent to do what I do now, which is to help families through the legal process to make sure that their kids with special needs get the services that they need. So with that being said, tonight we're going to focus on individualized education plans and 504 plans. These are two different ways that we can support children with disabilities in the school setting. So we're going to cover tonight your child's basic legal rights under our federal and state education laws. We're going to talk about what supports might be available if your child is struggling in school. We'll talk about what types of supports are available through an IEP versus a 504 plan. And we will talk a bit, as the last bullet says, about what you need to know to be informed, engaged, and empowered so that you can advocate for your child. So when we talk about IEPs and 504 plans, these come to us from federal laws. We have IDEA, which stands for the Individuals with Disabilities Education Act. That's what you see at the top left. That is our federal special education law. So that is the law that allows children with with disabilities who are eligible for special education. And we'll talk about eligibility criteria in a little bit. But this is what allows children with disabilities that are eligible for special education to have what we call individualized education plans, or IEPs, in school. On the right side there, we have Section 504 of the Rehabilitation Act. That is the federal law that allows for 504 plans. 504 plans are not unique to the school setting, whereas IEPs are. So IEPs are just for students with disabilities, whereas 504 plan, those are, anybody is entitled to those when they're trying to obtain public services. So it's not unique to just students. It also can protect people in the workplace, for example, or people trying to access public services like a post office. So Section 504 is much broader than just education, but it absolutely 100% includes education. IDEA, or federal special education law, at its very core, it's a funding statute. So it tells the 50 states that if they want federal special education dollars, they need to follow their rules. So here in New Jersey and in all states, we have adopted the federal law. In New Jersey, we have done it through the New Jersey Administrative Code, or NJAC, Section 6A:14. So if anybody wants to go and sit down and actually read the law in New Jersey on special education, that's where you would find it. You can just Google it. It will pop right up. It's very easy to read. It's set up in a format that you can understand, and it takes you all the way from initial referral all the way through to what happens if you have a dispute. So even after 20 years of doing this, it's something I still go back to and look at. And then we have the other state laws, Part 200 of the regulations of the Commissioner of Education. So those are going to be more just our general education laws. So those are the things that are governing special education and education here in New Jersey. Because the Individuals with Disabilities Education Act is a federal law, it is implemented almost the same from state to state, but there are some variations. In my practice, we work not just in New Jersey, but we work in New York, Connecticut, Michigan. My partner will actually take cases anywhere in the country. And again, 95% of the law is going to be the same state from state, but there are some nuances that you have to be aware of if you do have a child that's out of state and looking for services. But again, here in New Jersey, this is where we're going to look to see what the rules are. Okay, so what are we entitled to if we have an IEP, and what are we entitled to if we have a 504 plan? So an IEP is, as I said before, an individualized education plan. It is for students who have been deemed eligible for special education. It is a written document that outlines the special education and related services that a student will receive in school. So what classes are we placing them in? What related services? An IEP also includes goals and objectives. So what do we want to see the child achieve over the next year? And it includes progress monitoring. A 504 plan, on the other hand, is a plan outlining accommodations and related services that a student with a disability can receive in school. So the big difference is special education versus accommodation. So under a 504 plan, we're not providing different education, we are providing accommodations. Under both plans, however, there is this entitlement to what we call a free, appropriate public education. So whether you have an IEP or a 504 plan, the district's mandate is to make sure that your child receives this free, meaning at no cost to you, appropriate, meaning a program that is designed to meet your individual needs and designed to propel you forward, education. Okay, so let me shift to our next one. So under an IEP, we are providing that free, appropriate public education, or FAPE, in accordance with that federal special education law. So in accordance with IDEA. And the whole purpose of FAPE is to enable the student to make educational progress that is appropriate in light of his or her unique circumstances. So I'm going to pause there for a minute, because this entitlement to progress is at the core of what I do professionally. So when we are talking about whether a program is allowing a child to make appropriate progress, we are looking to see that the student skills are moving forward. If a student is stagnating, that's not progress. If a student is regressing, that's certainly not progress. So we are looking to make sure that the student is moving forward. Well, to what degree do they have to move forward? Do they have to make a year's worth of progress for every year they're in school? No, there's nothing in our federal or state statute that defines exactly how much progress is appropriate. It has to be individualized to the particular student. So if we have a student who has a severe cognitive impairment, progress for that student is going to look different than for somebody who maybe has a hearing impairment. So we always look at the student, their needs, and we set goals that we think are reasonable for the student to attain. And we are looking for the student to make what our courts have called significant and meaningful progress. Okay, so significant and meaningful. In some states, it used to be de minimis progress was enough progress to afford FAPE or that appropriate education. But our statute, or our courts here in New Jersey, have said it has to actually be significant and meaningful. So I know Kai put a question in here asking about, can I talk about what the E in FAPE means? So what does education include? That's a great question. Education is a broad concept, and our courts in New Jersey have confirmed that. So it absolutely includes academics. Of course it does. We want our education to include reading and writing and math and science and social studies, but it's so much more than that. Education includes communication skills, social skills, coping skills, behavioral skills. For some of our kids, it might include toileting skills. Education is whatever the child needs to learn to one day go out and be as productive of a member of society as possible. So we always want to take this very broad view of education. We don't want to just look at, oh, the student is doing well academically, so they don't need special education. No, we have to ask how they're doing in these other areas as well, because again, education is a broad concept. With that being said, a 504, oops, sorry, I just have to back up here. A 504 plan also entitles a student to FAPE, but instead of doing that through special education, we're looking at whether there's some accommodations that we can provide to allow the student to have their needs met as adequately as the needs of a non-disabled student. So let's talk about that. Let's piece that apart. The easiest way that I can explain what a 504 entitles a student to is to say that it is supposed to level the playing field. So if we have a person with a disability, we need to provide an accommodation so that that disability doesn't impede them from accessing some sort of public service. So I said before, let's talk about a post office. So any post office that you go to, these are federally, federal or state-run buildings, there is going to be a wheelchair ramp. And why is there going to be a wheelchair ramp? There's going to be a wheelchair ramp because we have to allow individuals who are in wheelchairs to gain access to the post office. If there were stairs, we would preclude those people from gaining access to the post office. Once somebody in a wheelchair is inside the post office, we don't have to allow them to skip the line. They get in line behind everybody else, but by providing the wheelchair ramp, we have now given them the same access to the post office as people who are not in wheelchairs. So that's an easy way to understand. Again, we're not giving an advantage, but we are giving equal access. In the school setting, an example that I think is easy to understand is if we have a student who has a processing deficit. If it takes that student twice as long to process something, in their 504 plan, we can call for them to get double time on a test. Okay, so we'll give them double the time. It takes them twice as long to process. And so now their disability is not impeding them from having the same access to finish this test as their other students. We've leveled the playing field by giving them the double time. We're not going to give triple time because that would give them an advantage. We're going to give double time. And again, that goes back to the statement on the slide here that we want to meet their needs as adequately as the needs of non-disabled students. I'm just scrolling here. There's a question about is there anything in the law or guidelines from New Jersey regarding parent involvement in 504s? This person says that as a parent, she's been denied participating in a meeting. So unfortunately, that can happen. With an IEP, within our special education code, there is a definition of who is part of the IEP team, and parents are considered such important members of the IEP team that they're actually listed first in the list of IEP team members. Therefore, a parent always has to be invited to an IEP meeting. The same is not true when it comes to a 504. A 504 committee is made up of school district professionals. It's unusual to hear that a parent was denied participation. I have 4 kids, 2 of whom have 504s. I've always been invited to their meetings. I haven't been denied participation, but again, there isn't something in the code that requires parental participation in a 504 meeting. All right, so let's keep going here. How does somebody become eligible for one of these plans? So you heard me say earlier that under the IDEA, a student can receive an IEP plan if they're eligible for special education. So a lot of parents come to us and say, my child has autism. He should be eligible for an IEP. That's not necessarily the case. To be eligible, it's actually a 3-part test. So number 1 absolutely is, does the student have a disability? So that is part 1 of the test. Part 2 of the test is, does the disability adversely affect the student's educational performance? So it's not enough to have an autism diagnosis. That disability, that autism, the manifestations of the autism have to adversely affect the student's educational performance. And then number 3 is, as a result of this adverse impact, does the student need special education and related services? So there are times when parents in a school district will have a dispute over eligibility, where a district will say, oh, sure, your student has a disability. Sure, it adversely affects them educationally, but they don't need special education as a result. So to meet eligibility criteria under our special education laws, you do have to meet all 3 parts of this 3-part test. That's to get an IEP. Again, an IEP is what's going to actually provide special education. A lot of times when a school district finds a student is not eligible for an IEP, they'll say, but the student may be eligible for a 504 plan. Let's go see the 504 committee. To be eligible for a 504 plan, a student has to have a physical or mental impairment that substantially limits 1 or more major life activities. Okay, so we're no longer talking about this adverse impact that requires special education. We're talking about an impairment that substantially limits 1 or more major life activities. I just want to point out that if a student has an IEP, they are also entitled to accommodations. So a 504 plan is just accommodations. An IEP is special education, related services, and accommodations. So there's a whole section of an IEP that includes accommodations. So if a student has an IEP, he or she does not also need a 504 plan. Any of those accommodations that they could get through a 504 would be included within an IEP. So we don't need both documents. If a student's eligible for a 504, they're eligible for those 504 accommodations through their IEP. Okay, so we have 15 different ways that a student can be found eligible for an IEP in New Jersey. So if a student meets that 3-prong test, there are these 15 different categories. I'm going to jump to the category at the bottom first, which is eligible for speech and language only. That is a separate IEP that only provides speech and language services. That's it. Okay. So if a student meets criteria just for speech and language, they can have a speech only IEP. Okay. The other 14 categories are the categories that we look to for somebody who's going to have a full-fledged IEP with special education and related services and accommodations. So we have these 14 categories. One of them is preschool child with a disability. That is the only category that a preschool child would have. So any preschool child is going to be classified under preschool child with a disability. When we get to regular school age, starting in kindergarten, a student is going to have one of these other 14 categories. So they could have auditory impairment. Obviously, that's for our kids who are hearing impaired. We have autism. We have intellectual disability. To be eligible under intellectual disability, the special education code actually defines what your IQ score needs to be. So there's mild, moderate, and severe. So there's 3 different levels of intellectual disability. That's going to be based on the child's IQ score. And we're going to have kids who have IQ scores starting at 70 or lower. On IQ testing, a score of 100 is perfectly average. An IQ score between 90 and 110 is within the average range. It's when we start seeing students with IQ scores below a 70 that we would look to this intellectual disability category. We have communication impairment, obviously for students who have some sort of language impairment. We have emotional regulation impairment. This used to be called emotionally disturbed. The state fortunately changed the name a few years ago. And emotional regulation impairment is the category that we most often use for our kids who have depression or anxiety to such an extent that it's adversely affecting them in school. When we look at the criteria itself, we're looking to see things like, does the student have an inability to build or maintain satisfactory interpersonal relationships? Do they have inappropriate types of behaviors or feelings under normal circumstances? We have seen a big rise over the past few years in school anxiety and school refusal. So that would fit under that category. We're looking to see if there's a general pervasive mood of unhappiness or depression or a tendency to develop physical symptoms or fears associated with school. So that's the emotional regulation impairment category. That's an area where oftentimes districts will say, yes, we know the student has anxiety. Yes, we know it's adversely affecting them in school, but they don't need special education. So that's a big area where we see a lot of disputes over eligibility. Multiply disabled is when you meet one or more of these categories. And if we focus on just one of them, it's not going to address the other. So we only use multiply disabled in situations where maybe you have a student who's hard of hearing and has a learning disability or something. We also have deaf blindness, orthopedically impaired, social maladjustment, let me go to other health impaired. This is the category that we most often use for kids with ADHD, but it can be used for kids who have other health conditions, but most of the time we're using this category when somebody has ADHD. Social maladjustment, in 20 years of doing this, I have never, ever seen a student classified under this category. Social maladjustment is a consistent inability to conform to the standards of behavior established by school. Again, I've never encountered a student with that category. A lot of times kids that are having those behavioral issues will be categorized under that emotional regulation impairment category instead. Specific learning disability, that's a big one. We work with a lot of kids who have learning disabilities. What's important to know there is that in our current statute, And there is a push to change this, but in our current statute, one way that a school district can determine eligibility for a specific learning disability is by what we call a severe discrepancy model. So we look to a student's IQ and we look to see if their achievement in one or more of 8 specific areas is severely discrepant from their IQ. Most school districts will say that to be severely discrepant, an achievement score needs to be more than 22 points below the child's IQ. Some districts do 20 points, but 22 points is the most common. So if you have an IQ score and you subtract 22 points, if your child has achievement scores in one of these 8 areas that's more than 22 points below their IQ, that would be considered an area of learning disability. The 8 areas are oral expression. So if your child's oral expression is more than 22 points or severely discrepant from their IQ, they can be eligible with a learning disability. Listening comprehension, written expression, basic reading, reading fluency, reading comprehension, math calculation, and math problem solving. So those are the 8 areas that we're looking at. So if your child is severely discrepant in their spelling, that's not one of the 8. So we have to look at the 8 areas that code. And then we have traumatic brain injury and visually impaired. Just looking at the questions here, Kai asked a question about how would a family determine whether an IEP or a 504 plan is more appropriate? Is it based on whether or not they're determined eligible for an IEP based on meeting one or more of the criteria? So you have to ask what it is your child needs, right? If you feel like your child just needs extra time or your child needs to have modified assignments, maybe instead of 20 homework math problems at night, they get 10. That's going to be more in the camp of a 504 plan. But if you really feel that your child needs some sort of specialized instruction, we have to look to an IEP. So for a student who is suspected of having a learning disability, and maybe that student might need some specialized reading instruction, we're going to want to look to try to get an IEP. Or if I go to the emotional regulation impairment category, a lot of those students need therapeutic schooling where they have access to counselors. They're in a therapeutic milieu as part of their school program. We're going to need to look to an IEP for that. So when a family comes to me and their child is not yet eligible, I always ask, what is it that you think your child needs? And based on what the parent thinks the child needs, that helps me understand, should it be an IEP or should it be a 504? We also a lot of times send our families to get private evaluations done. And that's a question that we pose to the evaluators. Do you feel that the child's needs warrant special education or do they warrant accommodations? So it's really going to be based on what you're trying to achieve. Again, special education, we can only get through an IEP. There's also a question about transition programs and if they're essential to implement in the IEP, and if they're not followed, does that mean the district is not adhering to an IEP? So we're going to get in a little bit to what is included in an IEP. So I'm going to table that question for a minute because transition plans are absolutely part of an IEP. They absolutely should be followed. An IEP is really a contract with the parents and the students to indicate what services the child should get. So yes, a transition plan should be followed, but we'll come back to that one when we get to the components of an IEP. When we look to Section 504 eligibility, as we said before, we're not looking to see, is there a disability? Does it adversely affect in school? And does the child need special education? Rather, we're looking to see if the disability substantially impacts a student's performance in a major life activity. So these are examples of major life activities. Caring for oneself, performing manual tasks, and obviously learning and reading and writing and things like that are on there. So if you have ADHD and it's affecting your ability to focus in the classroom, then you can get a 504, right? I mentioned before that my 2 daughters have 504s. My oldest daughter has one for ADHD. My younger daughter has one for anxiety. So they both need accommodations in school to help, like I said, level that playing field. Coincidentally, they both really most need just extra time, right? My daughter with ADHD needs it because she's inattentive. My daughter with anxiety needs it because she needs more time just to settle down and not freak out about the test that she's about to take. But that's really for both of them what they mostly need. Okay, so if we can establish to a district that there is a substantial impact from an individual's disability on their learning, then they can be eligible for a 504 plan. When you seek 504 eligibility, you do need a doctor's note, so confirming the diagnosis. So, okay, let's talk about identification. So we already talked about the 3 criteria for being eligible for an IEP. We talked about those 15 different categories under which a student could be eligible, but how do we get there? How do we get from this is a struggling student to this is a student who's actually eligible for special education? So in our special education law, the school district has an affirmative obligation called child find. So your school district is required under the law to identify children that might have a disability and determine, do they need special education? So anybody that works in a school district that comes in contact with the student, obviously it's going to be mostly teachers, are required to refer a child to the child study team. That's the team that assesses and determines special education eligibility if they suspect that the student might need special education. But you as a parent also can refer your child to the special education team. There are times where school districts don't refer, and they probably ought to have referred. Sorry, I have a client right now who's in 7th grade. Her school district never referred her to the child study team, and we had private testing done, and her reading is at a 2nd grade equivalency. How she got to 7th grade and nobody from the district raised an alarm is beyond me. We referred her to the team. The team then did their own testing. I think they were suspecting that their testing would contradict ours, but instead their testing came back corroborating our testing and showing just how learning disabled this young lady is. So just this week, we finally established her eligibility for special education. And again, it should be a district that refers, but parents absolutely can refer to the team and ought to refer to the team if they feel that something is amiss and we might need special education. There's a question about recommendations for obtaining private evaluations, and do I recommend that everyone gets one to supplement what the school has conducted? So in my practice, I do routinely refer parents for private evaluations. School district evals are very similar student to student. Most school districts are going to give the child the WISC IQ test as part of their psychological evaluation. The WISC is the gold standard of IQ testing, but it's not the gold standard for every child. The WISC manual actually cautions that the test might underestimate IQ for students with certain disabilities, autism being one of them, language disabilities being another one. The WISC IQ test is inherently language-based. Students are asked questions orally, so they have to understand what they're being asked, and then students give most of the answers verbally. There is a section of the test that is nonverbal, but most of the sections require verbal responses. If we have a student who has a language impairment, well, now we're going to interfere with their IQ testing. IQ is supposed to test your ability, but if we have a language disability, then we're going to muddy the waters on IQ testing, because now are we testing their ability Or are we just seeing the impact of their language deficits on their ability to answer these questions? So the WISC manual actually recognizes that we could be underestimating the IQ for those students. So there are other IQ tests available. For example, we have tests of nonverbal intelligence where we completely take away language from the IQ test. School districts very rarely do that. So when a parent comes to me and I see a student has a lower IQ score, but their nonverbal score on the WISC is higher, I say, you know what, maybe we should go get a nonverbal IQ test to see if, how they perform when there's zero language demands. For academic testing, the districts usually give the Woodcock-Johnson or the Wyatt. They're two very broad-based achievement tests. They're both very wonderful tests. They're insightful tests, but they're testing everything. They're testing all areas of reading and writing and spelling. The Woodcock-Johnson even includes oral language testing. So we're doing a lot of different skills at sort of a very surface level. To really dig deep, we just don't have time, right? There's too many subtests to get through. So a lot of times when we see an area of deficit on that testing, we do want to dig deeper. And private evaluators will go dig deeper. Sometimes districts professionals will. I've seen some really good evaluations recently from some school districts, but a lot of times they just stop at that broad-based achievement test. If I have a parent who comes to me and they are very concerned that the district's program is not appropriate, we are absolutely going to recommend that they get a private evaluation done because we want to investigate their concerns. I don't know what the outcome of the private eval is going to be. I always tell parents it's going to be money well spent, whatever the outcome. Either your private evaluator is going to evaluate. We always like our evaluators to observe in school so they can see what's happening in the classroom. So either our evaluators are going to evaluate and come out and tell you, rest easy, mom and dad, the district is doing everything they should, which, okay, money well spent, you can sleep better at night. Or the evaluator is going to come out and say, hold on, we need to make some changes, and they'll tell us what those changes should be. So we use those private evaluations all the time to investigate the concerns of our parents, and then to use that evidence to make changes or to request changes to a student's IEP if there are changes that the evaluator deems necessary. So when we refer for a private evaluation, we're looking at the area of concern, and that indicates which type of evaluation we might send a family for. Okay. All right, so let's keep going here. So once we're in the world right now of special education eligibility, so eligibility for an IEP. Once the child gets referred to the child study team, whether it's by you as a parent or by somebody in the school district, that child study team is required to hold a meeting within 20 days of referral. That first meeting with the child study team is called an initial identification and evaluation planning meeting. That's when the child study team will decide if there is enough concern to warrant doing an investigation into whether the child needs special education. A child study team, by the way, is made up of a school psychologist, a learning disabilities teacher consultant, and a social worker. If that team of 3 people feels like the parents' concerns or the teacher's concerns, whoever referred the child, are minimal, and we absolutely, under no set of circumstances, could envision this child needing an IEP, the child study team can say, we're not going to proceed with evaluations. On the other hand, if the team agrees that there is enough of a concern to warrant moving forward, the school district is required to evaluate the child in order to determine eligibility for special education. Under the code, they have to do at least 2 evaluations. Most of the time, districts will do a psychological, which is that IQ testing. Most of the time they will do an educational, which is that academic achievement testing we spoke about. And most of the time they'll do a social history, which is an interview with the parents to literally go back to the beginning of time and trace the child's history up to current date. As it says here on the slide, the district is required to evaluate your child in all areas of suspected weaknesses. So why those are the 3 standard evals A school district can and should do additional evals. Maybe it's a speech language evaluation or an OT evaluation or a PT evaluation. Sometimes districts are sending kids to their consulting psychiatrist for a psychiatric evaluation or to a neurologist for a neurological evaluation. If a student is suspected of having ADHD, for example, and the child has not previously been diagnosed with ADHD by a private doctor, then we have to go, the district will send that child or should send that child to either a psychiatrist or a neurologist to see if the child has that ADHD diagnosis. These school district evaluations are completed at no cost to you. Certainly, you as a parent always have the right to also do those private evaluations that we spoke about. If a district does evaluations and you disagree with those evaluations, a parent can also request what's called an independent evaluation. So a district evaluation is done by district professionals or district's consulting professionals at their cost. A private evaluation is done at parental expense. An independent evaluation is when we say to the district, okay, you just evaluated, we disagree with your results. We want an independent evaluation. An independent evaluation is paid for by the district, but it is conducted by people who don't work for the district, and that's why it's called an independent evaluation. If a family requests an independent evaluation, the district either has to agree to it or they have to sue the family. So if they want to object to doing independent evals, the district actually has to sue the family, and then we go into court to argue about whether the independent evaluations are necessary or not. When a parent has a private evaluation done, or even an independent evaluation, the district does not have to accept the results. They don't have to follow the recommendations, but they do have to consider those evaluations. So I've had some parents say to me, well, why would we pay for a private evaluation? The district doesn't have to accept it. You're right, the district does not have to accept it, but for us to have the ability to argue that something needs to change, we need an expert telling us that something needs to change. We're going to get into dispute resolution in a couple of minutes, but if a parent has a dispute with the district and they bring that forward legally, that family is absolutely 100% going to want to have at least one expert who supports what you're asking for. So having those evaluations done is very important to give you as a parent an expert opinion as to what your child needs. Okay, once a school district agrees to evaluate a student, this is the stinky part of it. They have 90 days to get those evaluations done. So when we refer a student for an evaluation, it's because something's wrong and they need help. But the special education law allows the district 90 days to get their initial evaluations done. 3 months is a long time when we're talking about a 10-month school year, right? That's almost a third of the school year that could go by while the evaluations are happening. A lot of the times we will recommend to our clients that if their child does not yet have a 504 plan, that they ask for a 504 plan in the interim while the evals are being done, just so the kids could get at least some accommodations in the meantime. And it also never hurts to ask for the district to expedite the testing. They don't have to agree. There's nothing under the law that would allow us to compel the testing to move faster than 90 days. But there are a lot of really wonderful child study team members out there who understand that sometimes it's more urgent and we need to get this testing done quicker. And so I always encourage my clients to ask for the testing to be done faster if possible. What happens within those 90 days, and it's 90 days from when the parent signs consent for testing. So remember, when you refer your child or the district refers, the district has 20 days to meet with you. So 20, almost, up to 20 days goes by before you have that meeting. If at the meeting testing is recommended, and you sign consent for the testing, it's 90 days from the date you sign consent. So within those 90 days, the testing needs to be complete. Reports have to be shared with you, and they have to be shared with you at least 10 days before the eligibility meeting. and you have to hold the eligibility meeting all within 90 days. So it's testing, sharing the reports, and holding the meeting. If you go to that second meeting with the child study team, and they review their reports and they say, based on our reports, your child is not eligible under any of those categories, a parent can object to that. A parent can file due process against the district if they disagree with the eligibility or the ineligibility determination. But if the district finds at the end of testing that the child is eligible for special education, they're going to let you know that at this eligibility meeting. They're going to tell you which of those categories the child is eligible under. And that's when we then move into developing the IEP. Okay, so let's talk about now developing the plan. So for an IEP, I went one too far. Hang on a sec. So for an IEP, once the student is found eligible, that IEP team includes, and here are the people there that we talked about before, parents are listed first. But also we include in the team that develops the IEP a general ed teacher, a special ed teacher, a district representative who has authority over special education. We include individuals who can interpret the evaluation results. Sometimes we include the student. We see that more at the high school level or like 7th, 8th grade. We're really not including our little guys in that process. And we can also include other people who are knowledgeable about the situation. So if a parent did have a private eval done, the parent can certainly invite their private evaluator to attend. The 504, it also is developed by a group of people. As I said before, we don't have to include parents. Most districts will, but you also include people who are knowledgeable about the student. Most school districts have, or all school districts have a 504 committee. Usually the principal of the school is on the committee. Sometimes they'll have like the student's guidance counselor be a part of their individual committee. Okay, so those are the folks involved in developing the plan. An IEP is a roadmap to your child's education. So an IEP is always going to start with the child's present levels of academic and functional achievement. So the IEP starts by telling us, where is the student today? If the student was just tested, we're going to summarize the test results. If the student has been in special education for a while, we're going to have reports from the teachers saying this is where the student is in each of these classes. Your speech person, your OT person, anybody who is involved in your child's special education is going to inform that present level section. So this is where the student is today. That's number one. Number two is we set forth the measurable annual goals and objectives. Where do we want the student to be a year from now? So we start with this is where the student is, and we go to where do we want the student to be next? Okay, so where are we looking for them to progress to over the next year? Then we say, okay, what programming does the child need to get to that point? So how do we get them from point A to B? This is where we'll include transition goals and services, which somebody had mentioned before. Every IEP starting at the age of 14 is going to include a transition plan, or it's going to reference if a student needs any sort of transitional services. The whole point of special education is to prepare kids to go out into the real world. And so we start thinking at the age of 14, what do we do to need to prepare this student? Is this a college-bound student? If so, what do we need to do to prepare them for college? Is this a student that is not college-bound and we're going to go into the workplace? What do we need to do to prepare them to go get a job? We also talk about program and placement. So what sort of special education does this student need to get from point A to B? Can they stay in the gen ed classroom with supports, or do we need to put them in a different classroom? And we talk about the related services. That's the speech, OT, PT, counseling could be a related service. And then we also talk about those accommodations. So again, those things that we would see in a 504 plan are also reflected in an IEP. So this is where we are. This is where we want to get to. What do we need to help the student get there? What program, what services, what related services, what accommodations? Okay, so that's the roadmap. we talked earlier about appropriateness. So a school district has to provide an appropriate program to their students who have an IEP. Appropriate, again, meaning the program that's going to allow the student to make significant and meaningful educational benefit. But the district also has to provide an appropriate program in what we call the least restrictive environment. So the law very much envisions that kids with disabilities are going to be kept alongside their non-disabled peers to the maximum extent appropriate. So we always have to ask, is it appropriate? We can only call a placement least restrictive if it's appropriate. So we start, if you look at the upper left-hand corner, by asking, can a student be appropriately educated in their local public school in a general education class? If yes, that's their least restrictive environment. If no, we can't appropriately meet their needs, then we shift over and say, can the student be appropriately educated if we keep him in the gen ed, but provide some supports, okay? Would an aid help? Okay, something like that. Or can we do general education with some response to intervention? So some general education, extra supportive classes. So we maybe pulling them for like some extra reading instruction. If that's appropriate, that's the least restrictive environment. If not appropriate, then we look to, okay, what about an in-class resource center program? That would be our team teaching model. So a gen ed classroom, but with 2 teachers, a gen ed and a special ed. If that's appropriate, it's least restrictive. If it's not appropriate, it's not least restrictive. We then look to resource centers. If that's not appropriate, we look to special classes with some inclusion. Maybe a learning disabilities classroom in the public school, or an autism class, or a behavioral disabilities class. If we don't have any public school options that are appropriate, then we look to private schools or other neighboring public schools. So we're looking out of district. If we can't meet the child's needs in district, we have to look out of district. For some of our students, we actually need to look to residential programs. So programs where they actually live at their school. There's really generally 2 camps of students that we would be looking for that for. Kids who have very, very serious levels of emotional and behavioral dysregulation, or students who are very low functioning and they need to live in a program so that they can be taught daily living skills, hygiene skills, things like that. So the teachers are actually in the dorm with them, teaching them how to cook and how to clean and how to budget, things like that. So a district always has to do appropriate. It also always has to be least restrictive. But appropriateness is always going to be our first and foremost consideration. If we can't find anything appropriate in the public school, we're going to have to look outside of the public school. Okay, so that's where a lot of the disputes lie that I handle, is a lot of times we're making the claim that a public school program is not appropriate and we need to go to a private school. Okay, a 504 plan, on the other hand, we're not defining the special education that we need to meet goals. There are no goals in a 504 plan. We're not tracking progress towards goals. We're just laying out what accommodations does the child need to remove these barriers to learning. So again, the example I gave of, do we give double time on tests and assignments? Do we give preferential seating? My daughter is allowed to wear noise canceling headphones in the classroom because, like I said before, she's quite inattentive. So she's allowed to wear those headphones when she's taking tests so that she's not distracted by the other students. A 504 plan will state what your diagnosis is, and it will state the accommodations. Some school districts will provide related services like speech and OT through a 504 plan. Others won't. So sometimes that's an area of contention as well. But we can do it. Some districts will, some districts won't. There's a question here about when a private evaluation finds a disability such as dyslexia and the school testing does not show enough discrepancy. The discrepancy model of eligibility, as I said before, where usually we're looking for that 22-point split, that's not the only way of finding a learning disability. It's one way. It is one of the ways defined in the code, but there are other ways to determine if there is a disability. And of course, our private evaluators, they don't have to stick to the severe discrepancy model. So this situation that this person has posted about, it happens a lot where a district might say, oh, there's not enough of a discrepancy, but our private evaluator says this student absolutely has dyslexia. It's impossible for me to say generally that student should be eligible. I would have to look at the testing and I would have to look at the circumstances to know if there would be an argument to make for eligibility. But again, not an uncommon situation, but it's one that we would have to really look at to see if we think we can make an argument to determine eligibility. Okay. Let's see, there's another one. There's another question about a student who has a health condition and a physical disability, and that student has an IEP for autism. Where would the 504 accommodations go? Can he have both an IEP and a 504 plan? You don't need both an IEP and a 504 plan. There is a section of the IEP specifically for accommodations. So anything that would have gone in a 504 plan is going to go in the IEP under that section. Okay. There's another section going back to the independent evaluations. So there's a question, can a family request an independent evaluation from a private evaluator if they're choosing? So technically, yes, you absolutely can, as long as the person is appropriately credentialed in the specific area. So if you're looking for a neuropsych eval, you have to have a neuropsych, right? Who's a credentialed neuropsych do that. While I say technically, yes, the problem is that districts also can limit how much they pay for an independent evaluation. So a lot of times the problem is our preferred evaluators charge more than what the district is willing to pay for. So if we end up in a dispute, you know, a lot of times we're ending up in like a mediation and we're talking about the cost of a private evaluation and we're trying to negotiate for the district to be able to get more. Okay. So that's the rub with these independent evals is, yes, you should be able to go to who you want to, but the district can also limit how much they pay. So sometimes we're trying to negotiate to get more funding so that we can, you know, better pay for an independent evaluation with somebody that we trust and we know is going to do a comprehensive job. Okay, so now we get to, let me see, did I skip a page? I did skip a page. Hold on, I think sorry guys, one sec. Okay, nope, I'm good. Okay, so when we have an IEP, it gets reviewed. So we don't put an IEP in place and set it in stone and never come back to revisit it. An IEP must be reviewed at least once a year. And changes have to be made if the program is not appropriate. We can also hold IEP meetings more frequently, but they have to be held at least once a year. Every 3 years, a district is supposed to reconsider evaluations. They don't have to reevaluate, but they do have to consider reevaluating every 3 years. I am a huge fan of testing, especially for our kiddos who have learning disabilities. I don't want to wait 3 years to make sure that they're progressing and their scores are going up. I always suggest to my parents of kids with learning disabilities, we want to test every year, because if a program's not working, if your program's not progressing, we don't want to wait 3 years to find that out. So as a parent, you can certainly request that a district reevaluate more often, or you can obviously do testing on your own with a private evaluator. Every IEP is going to include IEP goals and objectives, and we are going to monitor the child's progress towards those goals and objectives. Your IEP will say how often progress monitoring is going to be done. Is it 3 times a year? Is it 4 times a year? And we're looking again to make sure that the child is making meaningful progress. The progress does need to be more than de minimis or more than trivial, but a school district does not have to maximize your child's potential. And we want to make sure, as I said earlier, that a child is not stagnating or regressing. With a 504 plan, usually we are looking to re-update a 504 every year, but we just periodically are supposed to look at that. But again, usually most districts will do it annually. The next step is, well, what if we think this isn't working? What if we think the IEP is failing to allow our child to meaningfully progress? What can we do about it? Well, you ask for a meeting with the child study team. You try to problem solve. You try to roll up your sleeves and make this program work, or make revisions to it to make it work. But if you end up in a dispute with your school district, as a family, whether you have an IEP or a 504 plan, you are entitled to the same dispute resolutions, meaning you can file for mediation or you can file for due process against your school district. When you file with the New Jersey Department of Education. The New Jersey Department of Ed is going to give you an opportunity to try to work with the district to resolve your dispute before sending it off to court. If you can't resolve it with the help of the State Department of Education, then we go to court, and we have trials, and we give opening statements, and we take witness testimony, and we do closing arguments, and then it's up to the judge. The judge is going to decide if the district's program that you're saying was inappropriate is actually inappropriate, or if the dispute is over eligibility, the judge will say whether he thinks the district got the eligibility determination right or wrong. Under the dispute, we also have something called invoking stay put. This is going to be unique to our IEPs. So if a student has a program in their IEP and the district looks to change that program, let's use a very simple example of a child who's getting speech language therapy 5 days a week. If we go to an IEP meeting and now the district proposes to eliminate speech language therapy, child doesn't need it anymore at all. If a parent disagrees with that, as long as a parent sues the district within 15 days, so you actually have to sue within 15 days, and you have to, you're filing in the State Department of Education. It is not enough for you to just email the district that you disagree. You actually have to formalize a dispute by filing against the district. Once you file against the district, that is an automatic injunction against the district. It prevents them from making the change. I always say to parents, it is like a temporary restraining order. So your district just proposed in my hypothetical to do away with speech. Once you sue the district, they have to continue the speech therapy 5 days a week until either you and the district agree to something else. Maybe you agree to 3 days a week as a compromise, or you go to trial and a judge decides. And then everybody is going to have to abide by whatever the judge's decision is. But the whole purpose of stay put is that while the adults go off to court and fight, the child literally stays put and the child gets all the same services that were in their last agreed upon IEP. They don't receive any sort of hiccup, or they shouldn't, in their services. The services should stay the same. Parents also have the right to file what's called emergent relief. This is when we have an emergency situation. Going to court takes time. It could take months and months if you have to go through a trial before you get a decision. There are some situations where we say to a judge, we can't wait. We need a temporary order on an emergent basis. In order to win on emergent relief, you have to be able to argue successfully to the judge that your child will be irreparably harmed if we don't take immediate emergency action. And again, it's temporary. You still have a trial later. We just are asking for an order for something to be done while we wait to go to trial. So an easy example, and a very extreme example would be if a child has a seizure disorder and we're asking for a nurse on the bus because the doctor says we need a nurse, says, no, we're not going to give a nurse on the bus. We can sue the district. We can ask for a trial over whether the child needs the nurse on the bus, but we could also file emergent relief and say, if there is no nurse on the bus and the student suffers a grand mal seizure on the bus, that student could be irreparably harmed if there's no nurse on the bus. So again, an extreme example, but again, it's a high standard. So emergent relief is not available in all of our cases, but there are times when we absolutely need to ask for this emergency action. So that brings me to the end. We covered a lot. I'm going to look to see if there's some more questions here. There's a question about if psychoeducational testing shows borderline intellectual functioning for 3 consecutive years, should the district recommend consulting a doctor if they did not? So if they did not, are they not in compliance with child find? So if the district is doing testing, then they're not out of compliance with child find. They've done testing, okay? But if a student is showing borderline intellectual functioning, we're usually looking to a psychologist, right, to look at intellectual functioning. They're the ones that do IQ testing. So there's nothing that's going to require that the district consult with a doctor. But as a parent, if you feel like there's something being missed, you could always ask for, let's say, a neurological evaluation. And if the district doesn't agree, obviously you can always go to a neurologist on your own. There's also a question, what happens if the district won't look at independent neuropsychs or any outside evaluations? I've been told that they have to at least discuss at a meeting. That is true. As I said before, they are required to consider them. They are not required to accept them. So there should be some form of review by the district of your private evals. And if they don't, I would, and you sue the district, I would put that in the argument. Okay, we also have, does a district have to comply when asked by a parent to provide a copy of an IEP before the IEP meeting? So that's an awesome question. No, they do not have to provide an IEP prior to the IEP meeting. And in fact, I have beat up districts in court when they have provided an IEP in advance, because the IEP is supposed to be developed at the IEP meeting with the parents in attendance. So when they give us an IEP in advance, we make the argument that you predetermined the IEP without any conversation with the parents. So we always ask for it. We always would love to have that heads up of what's coming, but no, a district should not have to give it to you. And if I was representing a district, I would tell them never, ever, ever share that. So no, they do not have to do that. So then there's a question, are you able to share a list of neuropsychs that you work with?
On the car audio.
I don't know what background I'm hearing here. Can you hear me okay still? Okay. I have lots of doctors that I work with. I have lots of neuropsychs. I have lots of speech pathologists. I have lots of occupational therapists, neurologists. I don't ever just hand out a list of people. I always like to carefully match people to who I recommend. So I wouldn't be comfortable just sharing a list of people without knowing more about your child's specific situation. The question goes on to ask, would I move forward with a neuropsychological eval for an dyslexia for an 8th grader completing their 3rd year in a private school and returning to public school for 9th grade? 100%. If we are looking to move a student out of the student is at Windward. This is one of our wonderful learning disability schools. If we're looking to take the student from a very intensive learning disability school and put them back in the public school, I do always recommend that we have evaluations done so that we can hear from an expert what support should be in place when the student gets to the public school. We'll also ask our evaluators to go with parents to observe different public school options. Does this student who's been in a very intensive learning disabilities program still need some reading remediation? If so, show us, district, what sort of reading remediation do you provide to a 9th grader? Show us your resource center, show us your in-class support. So I always like to depend on experts to really guide us in what we're looking for. Okay. Okay. And then there's a question about what are the requirements to declassify a child? That's a great question. If we could no longer meet that 3-part criteria, we're going to start talking about declassification. I have
to get these special teachers and nurses to ride buses.
Can you please mute and put your question in the comments, please?
Yeah. So I have a client right now who's been eligible under the specific learning disability category in the area of reading fluency. She was just reevaluated after 3 years, and she no longer has a severe discrepancy in her reading fluency. Her reading fluency has actually improved very nicely with the district's instruction. So she is no longer eligible under that category. So the district, knowing that she still needs an IEP, is now looking for a different category. So sometimes we're looking to change categories if a child no longer meets one of, the category that they've previously been eligible under. But we're always looking to see, do we still meet that classification? Most districts will reevaluate before they move to declassify a student. And if a district moves to declassify a student without evaluating, I'm going to say that's not a good idea. We should probably evaluate before we make such a big decision to remove all special education supports. So then we have a question. What if a district doesn't comply with the judge's final order? So you go to court and a judge rules in your favor and a district doesn't follow it. You can absolutely go to the New Jersey State Department of Education and tell them, here is my decision. Here is what the judge ordered. The district is not following it. In fact, when a due process hearing is held and the judge orders something, the State Department of Education will actually actively they'll proactively call the school district to make sure they're abiding by the order, and they'll call the parents or the parent's attorney to make sure that it's being abided by. If you feel that it's not, you go to the State Department of Education and say, I need you to enforce this judgment. The district is not following it. The second part of this question is, what if the district retaliates against parents? I really hope that doesn't occur. I really, really, really hope it doesn't occur. I have a lot of parents who come to me that they're concerned that if they fight for something for one child, they might get retaliated against, or their other children might get retaliated against. I have to be honest, in my practice over the 20 years, I really haven't seen that so much. But if you feel like a district is retaliating against you, there's a whole different type of lawsuit. I don't handle those, but if somebody ever felt that was the case, we could certainly refer to somebody who handles that types of cases. There's another question asking, is the district in compliance if they're not clearly identifying and addressing the specific areas of deficit under the category of specific learning disability? The neuropsych eval we paid for out of pocket revealed several significant deficits that the child never received support for. Yeah, I mean, if you have evidence that your child needs special education in a certain area and it's not being addressed through the IEP, you absolutely should ask for it to be addressed. And if the district doesn't address it, you can sue the district. Obviously, we hope you don't ever have to sue the district. We hope that you can try to work it out. But I'm going to go back to that example I told you about before, where I have this young lady who's in 7th grade, never identified by the district as needing special education, and she is at a 2nd grade reading level. In our meeting the other day, the learning consultant who did the district's testing said to the family, your daughter's decoding is so poor, her reading fluency is so poor that she can't comprehend. Then the IEP called for absolutely no decoding instruction, no fluency instruction. It had no decoding or fluency goals. It only had a goal for her to improve her comprehension. So I pushed back and said, well, you just told us it was her poor decoding and her poor fluency that make her unable to comprehend. So why aren't we giving decoding and fluency instruction? And we then got a new version of the IEP that includes some reading remediation and additional reading goals. So you should absolutely ask if you feel that there's areas of deficit that aren't being addressed. Go in armed with the data from your neuropsych evaluation that shows these are areas of deficit, and ask for the district to update the IEP accordingly. And if you don't have success with trying to work it out with the district, you always have those dispute resolution options of filing for mediation or filing for due process. Just so you know, if you file for mediation, You have mediation with the district within 30 days. If you file for due process, you also have mediation with the district 99% of the time. So you still get that mediation, but if you don't resolve it, then your case moves on to court. If you file mediation only and you don't resolve it at mediation, you do have the option to convert to due process. But that's really just the basic differences between the two. Okay.
Lori,
Yeah.
one last question. I take
Yeah.
it that this person is having issues with their
Yeah.
district by the way they
Mhm.
are asking it. So we know you can't really tell us what to do in this aspect, but what kind of an attorney handles incidents of retaliation from the districts? What we're finding, at least in our group, and even my doing this for as long as I have, that is a very common problem in our state. And they're getting very, unprofessional with their retaliation. So could you tell us what kind of an attorney?
Yeah, so really those claims are going to be brought under Section 504 of the Rehabilitation Act. So the same law that gives those 504 plans, if you feel that there's retaliation because of a disability or because of you fighting or advocating on behalf of your child with a disability, you can file a retaliation claim under 504. Again, I don't handle those. Those are handled in state or federal court. But there are some attorneys that do that. I can certainly, Kai, I have your contact. I can send you like a name or two of people that I recommend after we're done, and you can share that with the folks. Okay. Anything else?
Hi. Oh, there you go. There you go.
Okay, I got unmuted. Okay, so Lori, thank you so much. That was so informative. I will
Good.
certainly take the contact because yes, like
Sure.
Deanna said, we are dealing with a lot of different retaliation things. And that can be a webinar for another day. So Deanna,
Yeah.
I will let you close us out. And I just want to say thank you to Lori 100 times over for your time tonight. This is going to be on our website, so we can access this anytime we need it, and we can, share it out as well. So Deanna, if you can close us out, we will let everyone get out of here and back to their evening.
Yes. Thank you, Lori, for sharing.
Thank you.
Really
Thanks for
was a
inviting me.
treasure having you here today. I do know you did answer a lot of questions that the parents had. If we weren't able to get to your questions, you can always post them in the private Facebook group, and we'll do our best to make sure you find the answers that you need. This may be a little bit off topic. This Saturday, we are hosting the New Jersey Education Expo. There are a lot of things happening this Saturday. Kai and I have worked very hard to pull this off for a second year in a row. There are going to be lots of giveaways. So make sure you pop on by. We'll be at the DoubleTree in Somerset from 11 to 2 p.m. This is just the beginning of content creation. Stay tuned for more webinars and resources from New Jersey Coalition for Learners. Together, we will ensure every learner has access to the education that will enable them to reach their future. So we thank you all for joining, and we hope you had a great time.